want your notebook? There's more.
And I'm Elizabeth Voss.
Talk of a plea deal for Julian Assange first surfaced at the end of May last year when it was first mentioned by Stephen Kenny, Assange's Australian lawyer. At the same time, Bruce Afran, a U.S. constitutional and human rights lawyer, told CN Live on May 31, 2023, that Assange could plead guilty to a misdemeanor for mishandling official information. He could enter the plea remotely from Britain, and he could be released on time served on remand. Then in August of last year, according to the Washington Post, Assange lawyers approached the Department of Justice with an offer of pleading guilty remotely to a misdemeanor. Caroline Kennedy, the daughter of a slain president and the U.S. ambassador to Australia, that month told a Sydney newspaper the U.S. was indeed open to a deal.
In March of this year, the Wall Street Journal reported that the U.S. Department of Justice and Assange's lawyers were exploring a plea deal in which Assange would plead guilty to a misdemeanor remotely. Meanwhile, after the U.S. was unable to provide an assurance of Assange's First Amendment rights in a U.S. court, the High Court in London granted Assange an appeal of the U.K. extradition order. A Department of Justice trial lawyer on Assange's case wrote in an email leaked to the Washington Post, quote, "The case will head to appeal and we will lose." The Post reported on April 4 that, quote, "Without the First Amendment assurance," one U.S. trial attorney said in an email, the British lawyers representing the U.S. government concluded they would run into, quote, "an ethical obligation to drop the case because of their, quote, duty of candor." They would no longer argue for extradition when a condition required by the court had not been met. That spurred the U.S. on to get something from a deal rather than completely lose the case on appeal.
What Assange got, his freedom after 14 years of arbitrary detention and then imprisonment in a maximum security jail. What the U.S. got, Assange pleaded guilty to a felony, not a misdemeanor, the only thing he actually did wrong, based on an unconstitutional provision of the Espionage Act, namely unauthorized possession and dissemination of defense information. In court on the Mariana Islands last week, Assange acknowledged that, as it is now written, he broke the law, but that the law conflicts with the First Amendment, in that it is not restricted to government employees who sign non-disclosure agreements, but extends broadly to anyone who has a possession of defense information without authority. Bruce Afran, who will join us on our show today, argued in an article in Consortium News last July that, in fact, the First Amendment authorized possession for Assange. The price for Assange's freedom was also that he agreed to order the destruction of unpublished WikiLeaks U.S. files. He had to indemnify the United States, give up his right to discovery, and to file Freedom of Information Act requests. And perhaps most significantly, he had to waive his right to appeal the Espionage Act's constitutionality, a waiver which itself may be unconstitutional. And there's the question of whether there's a price to be paid by journalists in the future because of this plea deal. On our program today is Marjorie Cohn, past president of the National Lawyers Guild and a board member of Assange Defense, Bruce Afran, a U.S. constitutional and human rights lawyer, as mentioned, and Alexander Mercouris, a legal and political analyst and the editor of The Duran. Thank you, all of you, for joining us. Let's start with Marjorie and then Alexander and Bruce. I just like your opening remarks, your reaction to this deal. Were you expecting it? Did you, like many Assange supporters, believe that he was going to wind up dead in an American dungeon? Marjorie.
Well, I had also been reading reports of a possible plea deal, but it wasn't until the High Court rejected the United States so-called assurances that Assange could raise the First Amendment issue with no guarantee that it would actually be effective in any way, that, as you said, the Department of Justice of the United States thought that their case was in jeopardy and scrambled. That's really what they did, according to a Washington Post report. They scrambled to get this plea deal. But I think that ultimately it's important to note that but for the efforts of Julian Assange's excellent legal team and a worldwide movement of activists sustained over many years to free Julian Assange, he'd probably still be languishing behind bars.
Jerry, you're muted.
Yeah. Alexander, can you hear me? I can hear
Yes,
Alexander.
yes, I can hear you now. I can hear you
All
now.
right, very
Yes.
good. Let's have your initial thoughts on this issue.
Yeah, well, my first view when I heard about this, my first feelings were one of immense relief that Assange is at last free, that this terrible Kafkaesque series of proceedings that we've had in England, we've finally come to an end to. And of course, it's absolutely clear that the final decisive thing was the High Court decision to grant him leave to appeal. And we discussed it at the time, and we were all in the view that more likely than not, it would mean that he would win the appeal. But it's important to remember that even if he won the appeal, even if the extradition request was refused in Kingdom,
Alexander,
I still feel myself that it would have been Assange, because he would have been basically, yes, yeah. Can you hear me now?
Yes, we can.
Yes.
Yeah.
It would have been a bad, yes, it would have been a dangerous outcome for Assange, because of course the moment he left the United Kingdom, the United States could have, in theory, resumed its extradition requests if he'd gone to any other country which the United States had extradition arrangements. He'd still have the case in the United States hanging over his head. And it's quite obvious that the British authorities did not want him here. They put him through an awful ordeal that's gone on for years and years. And the way in which he was led out of the United Kingdom with massive police escorts, police helicopters flying overhead, all of that sort of thing. An enormous show of force by the British, basically to show that they didn't want him in Britain. I think Britain has behaved very badly in this matter. I'm deeply ashamed as a British citizen that it has come to this. It was the correct for Assange to accept this decision. He is free. He is in Australia. And I personally think, and this is where I'm going to go over to the Americans, I think that in many respects, in legal terms, he's kept his ammunition dry. He's still got cases and arguments that he can make if and when he chooses to make them. Because my sense is that this is not the end of the affair.
Well, that's interesting, Alexander, because let's go to Bruce, and I like your initial ideas, and then I want to start asking you about this waiver that he had to agree to appeal. So that would put an end to this case. As Alexander just said, he doesn't think it's over. That's quite interesting. That's what I really like to focus on today. Bruce, your initial thoughts, and then this issue of the waiving of his right to appeal in the agreement. Mute, you're muted.
Thank you. I apologize, Joe. I was off for a moment, but I'm back. I did miss the very beginning intro discussion, but let me just say this. The settlement agreement, for lack of a better word, I think is obviously very favorable. You know, Julian spent these years in Belmarsh prison. Clearly, it's one charge. Clearly, it's essentially a defeat for the government's case. They never were able to put him on trial. They were never able to expose what they believed was illegality. He's getting time served from Britain. The US will never have him incarcerated. So this is essentially the government's way of saying we had to give in at this point. And it was very clear, as I heard you say earlier from the British counsel, that they were going to have to advise the British court that the case couldn't go forward any longer. Really for two reasons. The government could not really guarantee against, say, the Trump administration if it comes in seeking the death penalty. That's unlikely, but they couldn't guarantee it. But more importantly, They could not say Julian would have a First Amendment defense, namely that he's a journalist and he was free to publish under the First Amendment, because being outside of the US when much of this happened, or most of it, the First Amendment wouldn't cover. And that was a major barrier the government had to give up because British law would not allow this extradition. With respect, Joe, to the issue of appealing, in any criminal plea, generally the defendant gives up the right to appeal the merits. Often one can appeal the sentence, even though they can't appeal the guilty plea. Now, if Julian is barred, and this is part of what I don't know, if Julian is barred from challenging the espionage law itself in the future, that would absolutely be unconstitutional. To extract from a criminal plea a guarantee he'll never bring a civil suit challenging the illegality of the law, that's absolutely unconstitutional. Now, if it simply says he won't be able to challenge the constitutionality of his plea, that's pretty conventional. Once you plead and agree, you can't really go back and do it again and try to vacate it. Now, one thing I'll add, and then I'll stop talking for a moment, is that there may be times when, in the interest of manifest justice, one can go back no matter what the plea says. It's potentially possible, if it's later agreed the Espionage Act cannot extend to people like Julian, that Julian could then go back and seek to vacate that plea.
Are you saying that he cannot appeal this criminal conviction, this felony conviction, but he's open to filing a civil lawsuit in the United States on the constitutional issue of the Espionage Act? Is that what you said?
Oh, without question. I mean, he's clearly a person who's going to report on things similarly in the future. And like any journalist, they are faced with this constant threat over their head of decades in prison if they run afoul of what the government thinks is, quote, espionage, close quote. The Espionage Act is overbroad. It should not be written in the general terms it is. It should not apply to people working in journalism. It should apply to people who are giving secret information to enemy states or foreign states deliberately, not to a journalist who's publishing. I mean, the New York Times editors would have to be in jail for having published the Pentagon Papers on the same theory that the government is going after Julian.
Well,
So
Nixon did try to put him in jail. He impounded a grand jury in Boston to prosecute New York Times editors and reporters. Simply, it fell apart when they learned that they had surveilled their conversations with Ellsberg. But Bruce, I know you said you had to go, so I want to stay with you for a second. We read an article. I'm forgetting the guy's name, unfortunately, right now. I will put it in the. Sorry? Thorenson, his name is, in which he argues that these waivers of appeals in a plea agreement that became common in the 1970s and are included in almost every plea deal now, he argues it's unconstitutional in one way because it takes away due process from the defendant. It takes away oversight of the judge, whatever decision the judge makes in the case. The defendant can't know exactly what would happen at trial, so there won't be one. And there's also a separation of powers issue. The executive should not be able to shut out an appeal, make a decision about whether an appellate court can be involved or not. What do you make of that, Bruce, that argument? Is it unconstitutional?
Yeah. I don't think it is unconstitutional because, let's face it, when you have a contested case and the two sides agree to settle it by a plea, by a lower prison sentence, sometimes no prison, sometimes community service. I think the CIA director who mishandled documents was given community service with a plea. When you settle a contested case, really it has to come to an end. If you're going to settle it, serve 3 years in jail, then go back and reopen it again, or have no jail time, but then reopen it again, then really there's no incentive for anyone to resolve cases. The problem I want to say, though, is, and what I think is clearly unconstitutional, is this practice of overcharging defendants in the federal system. Julian could be hit with 50 years in prison. A typical case, when you add up all the charges, could be 25 years, even on a simple financial matter. And so many people are forced in the federal system to plead guilty because they can't run the risk of 10, 20, 30 years in prison. One executive, Tyco, was sentenced to 30 years, say, in New York State court for a financial crime. The same happens in the federal system. And so Jonathan Pollard was sentenced to life imprisonment for providing information, to an ally of the U.S. that arguably did save lives. Now, that was a violation of the law. He had to serve time. But the massive sentences that overhang people's lives force them to plead guilty. And this, I think, is unconstitutional. There's no justification for overcharging. There's no justification for piling sentence on sentence so that a defendant has no choice but to cave in. Let's face it, defendants' families are the ones who push them to settle because they don't want to see their husband or their father or their spouse or their wife spend decades in prison. And this is a major, major problem. The federal government gains pleas unjustly.
You make an extremely good point before that the entire U.S. government case collapsed against Julian Assange. There's no longer any hacking charge. What happened to this? Siggy in Iceland, who by the way, we spoke to a couple of weeks ago, he was ready to testify against Assange in Virginia and saying that he wasn't a journalist and all this because he had to rehabilitate his own reputation after he was seen to have lied to the FBI about this. And then we also had the informants. We heard endless talk in the extradition hearing from James Lewis, QC, representing the U.S. government about all the dangers that Julian Assange put U.S. informants. So that's all gone. And not only that, but the judge in the court in the Mariana Islands said that their WikiLeaks publications created no harm to anyone. They admit this in this plea agreement in the court. So all of that's gone. All that was left was this one simple charge. And I'm very pleased to hear that Bruce says he could challenge this in a civil case. Anybody want to jump in on these points?
Well, I'm going to jump in to one important point which relates to Britain. I mean, we've reached the point where the entire American case collapsed in exactly the way they said. We've reduced to one felony charge. The fact that he plead, well, there's the argument about the United States may not be prepared to entertain pleas under the First Amendment. All of this was floated and brought up very, very many years ago. I can remember these arguments having been made, and it has taken a huge amount of time, an inordinate amount of time and legal machinery in the United Kingdom for us to arrive at this point. However you look at it, and this is something which perhaps is incidental to Assange's case, but I feel it very strongly as a British person and as somebody who worked in the legal system here. We have come out very badly in Britain from this affair. Yes, we've got there in the end, but we've had to keep him in Belmarsh prison all of this time, despite the fact that this case in effect collapsed and collapsed so totally in the way that it has done. And I do hope that he does bring this case in the United States, this civil case in the United States. I've always felt as that the solution to this case lay within the United States, because if, of course, he is successful in the United States, possibly, conceivably, he has a compensation claim against the United Kingdom authorities for the way in which they've completely mishandled his case here. That's all I wanted to say.
You know, the problem with hoping that Julian will challenge the constitutionality of the Espionage Act in U.S. courts is that U.S. courts cannot be relied upon to sustain that kind of claim. I mean, we've seen what the Supreme Court has done over and over and over for this last week, and in fact, these last 3 or 4 years. And one of the things that Julian's plea deal does is to prevent ultimately the U.S. Supreme Court from saying that that provision of the Espionage Act is constitutional and can be used against journalists, which would result in even more of a chilling effect on the part of journalists who will not then report government secrets. And there's one other thing I wanted to add, and that is that there is no doubt that this is an excellent development and that Julian is free and can start the next chapter in his life with his family as a free man. But he was sentenced to 62 months in prison with credit for time served. And under the U.S. sentencing guidelines, the range for this offense is 41 to 51 months. And so Julian actually served 11 to 21 months longer than this type of case would typically garner. So yes, it's a very good development. I can't imagine that Julian is going to want to file a lawsuit and challenge the constitutionality of the Espionage Act. It would not be in his interest or in the interest of journalists in general to get a ruling from, say, the US Supreme Court that, in fact, it is constitutional to charge journalists under the Espionage Act.
You know, let me jump in if I can. I can't stay on too long, Joe, but I'm not sure I would quite agree that the Supreme Court is hostile to these issues. The recent decision on speech was really on standing grounds only. Just the week before, all of the Supreme Court justices, including the liberals, voted to recognize the NRA's rights to free speech and to be free from coercion by New York State. So I would say it's really more, unfortunately, a lot of times in federal court, it's a question of standing. Can you show, and the standing is very difficult in federal court, can you show you really are in jeopardy of your rights in a future instance? Will there be another Pentagon Papers, WikiLeaks scenario soon that another journalist can say, I need relief in advance from the Espionage Act? That's really the problem. The court is very hostile to cases unless there's a clear risk of harm to the plaintiff, and that's often hard to show. So you got to wait till the next instance occurs, then guess, can I take these documents and publish them? So I would disagree slightly with Marjorie, only in that I think the problem lies in standing doctrine. It's difficult to get a case because you don't always know whether you're going to be injured in the future. But I do think the court is open to free speech issues. I would say it is. I think this is going to keep happening. We've seen many instances of government leaks. So I think a challenge could be made. I'd like to see a challenge made to the Espionage Act. But as Marjorie suggests, if we're not going to win it, maybe we want to hold back. And that's always the problem in this type of analysis.
I wanted to jump in and ask you all, how much of a difference do you think the Assange activism made in this outcome versus the US basically facing the cold hard truth of the reality it was facing in the UK? You know, any of you want to jump in on that?
Well, I want to put in a plug for Assange Defense, which is the organization I've worked with. It formed in 2017, and it mounted dozens of campaigns, rallies, panel discussions, lobbying, op-eds, produced videos, had a webinar series with Stella Assange, included lawyers, journalists, professors, artists, doctors, free press and human rights organizations, and worked very closely in conjunction with other organizations around the world to lead to this result. And of course, his crackerjack legal team really did the work. But I am convinced that but for this worldwide activism sustained over many, many years, Julian would still be behind bars. And I think that there were probably political calculations going into this election, presidential election that's coming up. Biden did not want to be, he didn't want to face Julian Assange being extradited to the United States in chains, even though there is no unanimity in the left on Julian Assange and his case. But there would be a massive outcry, not just in this country, but around the world. So I think that political calculation probably figured in as well. But I can't underestimate the importance of activism on the part of, and the people on this, in this program as well. Joe has done tremendous work covering this case. Many of us have. So I think that's really critical. And Julian himself, of course, does acknowledge that in his most recent statement.
Well, thank you, Marjorie. But despite human rights groups, press freedom groups, president of Brazil and Mexico, all the demonstrations, everything that you just mentioned, it seemed like the U.S. Department of Justice, mostly because of what I think the CIA's involvement in this, resisted dropping this case until they knew they were going to lose. I think if they thought they could win that appeal, they would not have dropped it. That's just my opinion. But and not to say that there wasn't the value of that pressure. They felt the pressure, but that last point had to be that they were going to lose. I think they were resisting that pressure all along. Anyway, back to Elizabeth.
Yeah, so my next question was
Oh.
just about the kind of the speculation we're seeing right now on social media, a lot of misinformed discussion around what WikiLeaks had to delete from and destroy, people saying that it was the DNC emails when clearly it wasn't. The websites had issues for years around those emails. So can you discuss for us within the plea deal, what does it say that WikiLeaks have to destroy, and what, to whatever extent you can guess, what would that have been in reality? Would it have been information that was old or that was to be published in the future?
Right. It's not really spelled out in the plea agreement, but it does say unpublished reports and documents, etc., things that have not yet been published. And I think I would like to use this moment as an opportunity to remind everyone why Assange was indicted, and that is not for the Hillary emails, not for these unsubstantiated allegations in Sweden, but for revealing evidence of U.S. war crimes. I have a new piece out in Truth Out that details the war crimes, but just briefly, the things that are the subject of this indictment are revelations that Chelsea Manning provided to WikiLeaks in 2010, and they include the Iraq war logs, 400,000 field reports documenting 15,000 unreported deaths of Iraqi civilians and the systematic rape, torture, and murder after U.S. forces transferred detainees to a notorious Iraqi torture squad. They contained the Afghan War Diary, which was 90,000 reports that documented more civilian casualties than coalition forces had admitted to. They included the Guantanamo files, 779 secret reports containing evidence that 150 innocent people had been held at Guantanamo for years, and nearly 800 men and boys had been tortured and abused in violation of the Convention Against Torture and the Geneva Conventions, and the infamous 2007 collateral murder video, which depicts a U.S. Army Apache attack helicopter crew target and fire on civilians, killing 12 of them, including 2 Reuters journalists and a man who came to rescue the wounded. 2 children were injured. A U.S. Army tank drove over one of the bodies, cutting it in half. One pilot said, "Look at those dead bastards." The other pilot said, "Nice." This collateral murder video reveals evidence of 3 violations of the Geneva Conventions and the U.S. Army Field Manual. And these are really critical, these revelations. And this came out at Julian Assange's extradition hearing, that the war logs are the only source of information regarding the many thousands of violent civilian deaths in Iraq between 2004 and 2009. And there was testimony at the extradition hearing that WikiLeaks cables contributed to court findings that the drone strikes were criminal, and criminal proceedings should be begun against senior U.S. officials. So we get sidetracked with this whole issue about Hillary's emails and what did or didn't happen in Sweden. And we've got to keep front and center in our minds that what Julian Assange and WikiLeaks did was to reveal evidence of U.S. war crimes. That's why he was indicted.
I think this is why the First Amendment issue loomed so large in the extradition hearings, because obviously without this argument, Julian would be subject to a type of kangaroo court because there's no defense then. And so the First Amendment had to come into play because of exactly what Marjorie points to. And so this was the key to the case in Britain, that if he had no First Amendment defense, no free speech defense, then he really had no defense at all, and he's being extradited for an automatic conviction. And I think this is what ultimately was coming before the British court. And I also want to add one comment that I think the US caved in, so to speak, in large part because it knew it would lose. And assuming that would happen, as Alex was saying, that would be a great moment for British jurisprudence. We didn't quite get there, but it would have been a great moment for the law. It also would have been a huge blow to the US from a foreign policy point of view, that the US's closest ally is essentially giving it the diss and saying, we're not going to recognize the fundamental fairness of your court. And so I think the US wanted to avoid that loss in the UK, which would really have undermined America's standing. So I wanted to add that additional point. I think that's one of the things that motivated the settlement, the impending loss in the British court. It would have been a great moment for British justice, but a low point for America's standing.
After many low points for British justice along the way, because can I just say, I mean, one of the things to bear in mind is that over the course of these proceedings in Britain, we've had a number of statements from British judges which are frankly concerning about the status of journalists in the United Kingdom. Now, as I say, we were gradually moving, well, not gradually, we were moving finally towards a recognition of the key point that Bruce Afran has just been talking about. But it's taken us a very, very long time to get here. And as I said, judges have said various things at various times, which really are not good for journalists. I mean, including drawing distinctions between people who are journalists and people who they say are not real journalists. And it's grading, things like confidentiality between attorneys and clients, things of this kind, which really are concerning. Now, none of these statements that British judges have made are determinative. They can't be cited as precedents. And I think it's an important point to say, but they are there, and they are going to make journalists, the work of journalists in Britain, already concerning, more concerning. And that's why I would have liked to have seen a final clear outcome to this case. For me, the biggest single argument, by the way, speaking as a non-American, I can't comment on legal proceedings in the United States and how they would go. But after this terrible ordeal that Assange has been through, he deserves time out. He deserves time with his family. He's going to need to recover his strength. He's going to need the support of all of those people who have been supporting him up to now. That support is still needed. By the way, I completely agree about the critical importance of all those activists and all of those people who have been arguing on his behalf. I completely agree with the points around his legal team, who have in very difficult circumstances done a superb job for him in the United Kingdom. But after the ordeal that he's been through in the United Kingdom, he is going to need a time to put himself together, and whether he'll want to undertake more litigation in the United States at some point in the future. Well, all I will say is he would need to be a very remarkable man to do that. But I think he is. I think he is an unusual person and a very strong-minded person indeed, as we've seen through this case, and perhaps at some point he will. But if he does, I hope the best for him. I hope he has a good outcome in the United States. I'm very conscious of the points that Marjorie made, that if it goes badly wrong, then it will put us in an even worse position. But anyway, we'll see what happens.
I do want to add, Julian. I'm sorry, go ahead, Marjorie.
Yeah, I want to add a quick point about the First Amendment. It's not that British law reveres the First Amendment to the U.S. Constitution, but the European Convention on Human Rights prohibits interference or protects the right to free expression. And that's what the British court here was concerned about, that if Julian Assange were denied a First Amendment defense in the United States, that would violate Article 10 of the European Convention on Human Rights. And Britain and other European countries, unlike the United States, really does pay attention to international law. And that is the European Convention on Human Rights, which is a regional body that's administered by the European Court of Human Rights. And if Julian Assange had lost his request to appeal, then the next step would have been for him to file a request for review in the European Court of Human Rights.
You know, there's an irony.
Can I just quickly make a point, which is, of course, that the European Convention on Human Rights is actually incorporated into English law. English courts are supposed to prioritize it in every case. And that is as part of English law now. Obviously, Marjorie is absolutely correct, but it was brought up in the initial proceedings. It's taken a very, very long time. That's all I'm saying, before finally we got to the point where this very obvious and key fact was finally accepted.
You know, the law treads so slowly that it's often unjust. We often get to the right place, but the time spent is often unjust. I'm about to leave here to finish an appeal brief on a case I won a remand on in 2016 for an inmate. We've now spent 9 more years trying to gain his freedom. We may win it, but why 9 years from the last time we were on appeal? And Julian experienced this, and we do need to look at this carefully. Are we taking so long in the law that we're really affecting an injustice? On the other hand, many of these issues would not have properly percolated had enough time not gone by. So it's always a balance in law. Do we go too quickly and do we risk injustice that way? Or do we commit injustice on the other hand by taking too long? It's such a perilous balance that unfortunately someone like Julian gets caught in the middle. Probably this extradition process should have taken 3 years. And perhaps he need not have been kept in Belmarsh. There should have been a way for him to be under house arrest or something similar without this harsh imprisonment pending the extradition hearing. I want to just make one comment. As a slight irony, the British court was trying to enforce, so to speak, the U.S. First Amendment law, which is really much broader than anything in the European system or the British system. So there's a kind of irony that the British court was worried, will Julian have those bigger rights that nobody in the UK or Europe really has? And there's a certain irony to that. But I would say that it is at least over. However, Julian's not entirely out of the woods. He may not be able to travel to certain countries because of this felony conviction. And if he seemed to have breached his settlement agreement, he could be subject to extradition yet again if he travels in certain places. So Julian might have an interest in trying to set this aside by challenging the constitutionality of the act itself. But he's been through hell, and he needs time, no matter what, to see where he goes in life.
We need to keep in mind that this indictment never should have been filed in the first place.
Right.
Barack Obama, whose administration prosecuted more whistleblowers than all prior presidential administrations combined, convened a secret grand jury to determine whether or not to indict Julian Assange, and decided not to because of the so-called New York Times problem. And that is that the New York Times, Der Spiegel, Le Monde, the Guardian, all did what WikiLeaks did. They published what WikiLeaks made available. And so if they punished Julian Assange, if they indicted him, then they might have to indict people from all of those, the New York Times, etc. It wasn't until Donald Trump came along, who exercised no such forbearance and filed an indictment, then a superseding indictment, then another superseding indictment. His administration did that. And then along comes Joe Biden, who loves to talk about my buddy Barack, and we did this and we did that. But he continued Trump's pursuit of Julian Assange. He could have dismissed that indictment and dismissed the extradition request, but he didn't. He kept it going all these years, 4 years now during his term, until his Department of Justice finally struck this plea bargain. So Julian Assange never should have been indicted in the first place.
Joe, I'm going to have to leave. I'm afraid my appeal client in prison is calling me, but I just want to thank everyone. It's good to be with everyone.
Thank you, Bruce. Thank you very much for coming on.
Thank you. I'm sorry to have to leave.
Press for time. That's okay.
Thank you.
Well, I want to ask, before I get to the last question, which is about the future, Julian's future, I wanted to see what Alexander's reaction was to Marjorie saying that Britain respects international law more than the United States, particularly since this conservative government, which is probably going to be voted out in a couple of days from now, wants to leave the European Convention on Human Rights so that we no longer have to follow Article 10, which, by the way, gives freedom of speech to everyone, not just to American citizens, as we learned throughout this Assange case. But anyway, Alexander, not to start an argument with Marjorie, but do you agree that Britain respects international law more than the U.S.?
I think many British people would be surprised to think that. I mean, perhaps we do respect international law a little more than the United States does, but maybe that's not such a high threshold, if I have to say. The fact is, we got there in the end. I mean, the leave to appeal decision was, I think, critical. It took us an inordinately long time to get here. I think the judges did not want to do this. They did not want to go against the American extradition request. I think there were considerable political pressures in Britain that wanted to have him extradited to the United States. I think the British, had it been other countries, would have taken a much stronger stance against extradition much earlier. But anyway, we got here, and I'd like to believe that my country actually observes international law. I'm afraid I think that there are too many exceptions now to that for me to take much comfort. But anyway, the point is, for the purposes of where we are now, Julian Assange is free. He's with his family. He's in Australia. He's in a position to put his life back together. And we must all be grateful for that. And the outcome of the case, from a legal point of view, I think has been more positive than it looked, certainly than it looked as if it might be at one point. And I think that it's left us in a position where we can argue the case for journalists more strongly in the future. So I think we need to be grateful for all of that.
When you said, Marjorie, that Biden could have dropped this case. He, in 2010, said we can't prosecute Julian Assange unless we could prove they actually stole the documents. If they were given to him passively, as a journalist, we can't prosecute him. Then the Obama administration tried to frame Julian in Iceland with this phony story. The FBI told Iceland, "You're under cyber attack. We want to come there and save you." And they actually went there to link Julian to this fake plot to undermine the infrastructure of Iceland. The interior minister at the time, who was on this very program, told us he kicked the FBI out because of that. So that's the Obama administration trying to get Julian to prove that he did stole the document. They couldn't, and I think that's when they dropped it. But the Vault 7, which is not part of the indictment against him, is what really incensed the CIA to the part where Pompeo, in his first speech, called WikiLeaks a hostile intelligence agency and non-state intelligence agency, and then actually plotted to try to kill him or kidnap him. And this is why I think the CIA, right to the end, until the U.S. could not win this case, wanted to keep pressing this. Joe Biden would have had hell to pay from the CIA and the DNC because of the DNC leaks. So is Alexander back? I'd like to end the program now by talking about Julian's future. He's here now, of course, back here in Australia, where we came. We did not get to see him yet. We hope to do that before long. Tomorrow, on Wednesday, there's a birthday party in Melbourne that we're going to for Julian Assange with his father and other guests. But there is a comment from, and I hope I could find it now because I've had a difficulty. There's a comment from the Foreign Minister of Australia, Penny Wong, in which she says essentially we have laws against publishing secret, against revealing secrets. And we want to make that clear that this position, this is the position of the government. Now, the opposition here against the Labour government has been very critical of the Prime Minister for calling Julian when he arrived, and they've been trying to make political capital out of this. So this remark from Penny Wong reminding the public that Australia has laws that could prosecute a journalist. There is no protection for journalists here. A journalist can be prosecuted for publishing secrets, and she made that clear. So I want to know what do you both of you think of the future of Julian Assange? Is he safe? Could he be safe, other than maybe a country like Macedonia, which doesn't have an extradition treaty with the U.S.? Could he be safe in Australia? What do you expect him to be doing after he regains his health? Marjorie.
Yeah. The problem is that whenever journalists publish information, classified information, documents critical of the government, whichever government, they're going to come under fire. And Julian Assange is very well known. His case is renowned around the world. So I can't predict what he's going to do. I think he needs to, and he probably will, take a lot of time for himself to be with his family. He's never been with his children except short visits when he was behind bars. But I don't think we've heard the last from Julian Assange. I think he is going to continue to do really courageous work. What form that will take, I don't know. Certainly Albanese, the Australian Prime Minister, put a lot of pressure on the Biden administration to end this prosecution and drop the extradition request. And people all over Australia were really demonstrating for Julian's freedom. Many people in Parliament, in the Australian Parliament, wanted that prosecution dropped. So where could he be safe? I don't know. I really don't. We will see what the future holds, but I know that we have not seen the last of Julian Assange.
I mean, I'm not an expert, obviously, on Australian law, but I'm going to make a guess that Australia has followed very closely in the footsteps of the former British metropolis, Britain, which, as you know well, Joe, has very, very strong laws against journalists, the Official Secrets Acts. In their many iterations, you've written about this very, very thoroughly and eruditely in Consortium News. So I suspect Australia has followed in those footsteps. And of course, going back to the point that Marjorie made earlier, the critical difference is that Australia is not a party to the European Convention on Human Rights. So that's probably the difference, that in Australia, he doesn't have those protections that, at least in theory, he now does have in Britain. So that's in some ways, he's in a weaker jurisdiction in terms of protection of journalists. But I'm also going to say this, though legally the position in Australia
this slide
might be more difficult for him, is probably more sympathetic. Yes. Can you hear me?
Yes.
The culture there is probably more sympathetic. Australia has a history of pushing back against the British, especially, but I suspect domestically as well. They're more willing to allow open debate. They're more supportive of reporting. There's been cases where in Australia, books have been published which the British have not wanted the Australians to publish, and which have provided information which the British didn't want to see appear. So he probably has that protection. And he's also in his own home country. And I get the sense that a lot of people in Australia also feel strongly supportive of him as a fellow Australian who has taken a stand. So I certainly think he's safer in Australia than he is in many other places. And I think he will be able to do his work as a journalist, if that's what he chooses to do, more safely in Australia.
Then elsewhere, I presume Alexander was about to say.
Would
spike,
if
yes.
he came back to Britain, for example, another place. Yeah, exactly.
Okay.
No,
Spycatcher
I
was
mean,
the book you were referring to.
That's I think my main point.
Yeah,
Spycatcher is the book I was referring to.
Yeah.
Absolutely.
You know, they do push back against Britain ever since Britain decided not to defend Darwin during the Second World War, and the Americans did. So they don't stand up to the Americans, however. And if the Americans will keep an eye, certainly on Julian Assange, who right now is in a location very few people know about. We have heard where he might be, but we're not going to reveal that. But certainly the CIA knows where he is, and they've got their fingerprints all over this case, especially after the Vault 7. Let me just ask two more quick questions if I can, since we haven't.
I'm going to have to jump off, Joe.
Oh, Marjorie, could I ask you about legal precedent? There is, what should journalists in the future fear from this plea deal? Anything?
Well, there is not legal precedent insofar as there has been a ruling by a jury that Julian Assange is guilty of charges under the Espionage Act. But as a practical matter, by pleading guilty to an Espionage Act charge, this will still have the effect, unfortunately, of chilling journalists from reporting government secrets and inhibit and impair the work of investigative journalists. I'm not saying that he shouldn't have struck that plea deal, but after journalists around the world see what Julian Assange has suffered these last 14 years, that includes 5 years in a maximum security prison in London, before that a virtual prisoner, but under a grant of asylum in the Ecuadorian embassy, they're going to think twice about what they write. So I think that ultimately it will have a chilling effect, but not to the same extent as it would have if it had gone to a jury trial and there was a conviction under the Espionage Act.
Thank you very much, Marjorie. Alexander, I'll give you the last word.
It's the same in Britain. I mean, there is no final precedent here. What we have, though, is a situation where the British courts have shown that they're not sympathetic to a journalist. We've had a massive litigation to get to this point, but we have avoided the ultimate disaster of an extradition decision to the United States. That would have been a disaster for journalism in the United Kingdom as well, but we didn't get there. So we don't have a precedent, but we've had comments from judges that are concerning, and we have had an attitude from the British government which is concerning as well. So having said that, let's not be pessimistic. He's free. He's able to rebuild his life. He'll probably want to become a journalist again. And the battle, instead of being lost, as at some points it looked as if it might be, is still there to be fought and won.
Wonderful, Alexander. Thank you very, very much for your time taken away from your excellent reporting on Ukraine, the Middle East, and everything in between. So we thank you again for being on CN Live. We thank Marjorie Cohn, who's left us now, and Bruce Afran earlier for this very important discussion of the aftermath of the plea deal of Julian Assange, which saw him freed finally and returning to his home here in Australia. For CN Live and for Elizabeth Voss, my co-host, and Kathy Vogan, our producer, here in Sydney, we say goodbye.
Get out your notebook. There's more.
If you are a consumer of independent news, then the first place you should be going to is Consortium News, and please do try to support them when you can. It doesn't have its articles behind a paywall. It's free for everyone. It's one of the best news sites out there, and it's been in the business of independent journalism and adversarial independent journalism for over 2 decades. I hope that with the public's continuing support of Consortium News, it will continue for a very long time to come. Thank you so much.